Supreme Court of India Navin Kumar Rai vs Surendra Singh and others decided on February 14, 2024 SEC Online SC 145 Facts of the case. 1. Purushottam Kumar, A1, forged a power of attorney 2 on the basis of which transfer of certain land in favor of Bikash Kumar Singh, son of Surendra Singh, A2, Surendra Singh, A3. With the latter witnessing the sale transaction stood registered with the registrar having competent jurisdiction at a place known as Jirati. The original owner Navin Kumar Rai, having learnt of such an illegal transaction instituted proceedings before a civil court seeking a declaration of the transaction to be null and void. Independently, the district deputy registrar, Jirati initiated an inquiry on the basis of such an inquiry both the documents i.e., the POA and the sale deed stood cancelled. Further, FIR sections 420, 467, 468 and 471 of IPC bearing stood registered by Sadio Mera, against 7 accused persons including A1, A2 and A3. The accused persons preferred separate writ petitions and High Court quashed proceedings. Findings of the court, Section 82 and 83 of the Registration Act, 1908, empowers the Inspector General, the Registrar, or the Sub-Registrar, in whose territories, district, or sub-district, the offence stands committed to commence prosecution. It is not in dispute that the communication dated October 15, 2020 resulting in registration of the FIR was that of a competent authority i.e., the sub-registrar of the concerned district. In any event, such a power is the result of an action only in reference to and in connection with the Act and not the general provisions of IPC in relation to other penal provisions for which the FIR actually stood registered. It is all too well settled that while exercising such inherent powers what is required to be examined is only the prima facie existence of the offence sought to be quashed. The court's observation that because there is no order of the Inspector General, in spite of that this FIR has been lodged by the district sub-registrar, Jirati, which is against Section 83 of the Registration Act 1908. As demonstrated, supra, is completely divorced from the text of the section itself, for, it provides, as reproduced above, that a prosecution may be lodged by or with the permission of the sub-registrar in whose territory the offence has been committed. It is for both the above reasons that the exercise of power under Section 482 crpc, in the attending facts and circumstances, was unjustified and entirely unsustainable. The FIR in the consequent case, quashed vide the impugned judgment stand restored to the file of the concerned district court. All consequential steps may follow including the trial court commencing proceedings as per law. The criminal appeals are allowed.